Hello everyone, welcome back. Another video for Saturday. I want to talk to you again in this video about the Baker Act. You know, that's my favorite topic. And in other videos, I've talked to you about how, facilities can, how patients can go from voluntary to involuntary, involuntary to voluntary. And I've sort of explained that process, right? If the facility is holding you on an involuntary basis, they can get you to agree to be voluntary. And I mean, I've talked about that a lot, about how it could be coerced, how you can be tricked, threatened, all of that stuff. So you can go from involuntary to voluntary. So you go from a 72-hour hold to an indefinite hold. But then I'm seeing a lot of cases where somebody says, oh, no, they re-Baker Acted me and I've gone from voluntary to involuntary. And I think I told you in a prior video that that doesn't work that way. You can go from involuntary to voluntary, but you can't go from voluntary to involuntary. They can't switch you back, right? However, what they can do, and I think sometimes the facilities mislabel it or they just lie to people, we see that a lot too, is if you're voluntary and you revoke consent to be there on a voluntary basis, the facility, within 24 hours, if they don't release you, they can file a petition to keep you. And remember, I told you that petition is what triggers the hearing, which takes place somewhere between 0 and 5 days from the date of filing. And at that hearing, they can ask to detain you somewhere between 0 and 6 months. And if you've got a loved one detained and you don't think it can happen, I'm here to tell you that it can happen, and it does happen, and we see those cases. Sometimes before, sometimes afterwards. They will, if they think they can build a case and they have a financial motive, they will look to keep your loved one for as long as possible. But sometimes what happens is, so you revoke consent and the facility goes and files, okay? And now they say, they tell you they have switched you back to involuntary, okay? That is not what has happened. What they have done and what they have not disclosed to you is, in fact, they have filed to keep you. So when they tell you you've gone from voluntary to involuntary, that's not correct. The statute allows them to detain you, to keep you until there's a hearing. But if they tell you, and you're voluntary, that they switched you back, what that means is, most likely, unless they're just flat out lying to you, and, well, I mean, who can imagine that, right? Unless they're flat out lying to you, if they tell you they have switched you back, it means they filed to keep you. It means there's going to be a hearing, which you will probably find out about, unless you hire my firm. You'll probably find out, the morning of the hearing, when it's really too late to mount any kind of credible defense for you. You'll find out that morning that, in fact, there's a hearing and they're planning to keep you somewhere between 0 and 6 months. So I wanted to clarify that because we get a lot of these questions and it's very confusing. And look, if you're watching this video and you want me to clarify, you want me to make another video, yeah, let me know. Just message me on the post that you see me on. And it may be Facebook, LinkedIn, Twitter, Instagram, YouTube, Vimeo, wherever you find me. Post a comment and say, hey, can you do a video about this? And yeah, if I think it's video worthy, yeah, I'm happy to do it. I want to give you folks as much information as I can for free without having to call me or email me, so that you know what you're dealing with, and you know if that's the point in which you need to pick up a phone and call us and retain us and get us working on your loved one's case. So anyway, with that said, enjoy what's left of Saturday. See you in the next video. Bye-bye.